board appointed, the staff hired. Then you've got people starting to apply, and from what we've heard, it takes roughly 6 months to go through the application process and get approved. So there's a year into the 7. Then they have to, if they're in fact starting up something new, they have to get their investors, they have to develop their own processes, write the software if that's what's involved. So that's another period of time. So there's a major investment of time before they start seeing their first client. So I think that needs to be taken into account. In terms of the phase out, if I go back to what Adel's recommended, it was, as it goes along, if somebody is screwing up, you throw them out now. If it gets to the end of the process, then there's 2 options. It worked, and we now go through the statutory or rulemaking process to allow it for everybody, or we end it, and they would stop. So if it's not, it may be that it's not, ripping people off, but if it's not delivering the other part of the goal, which is the access to justice piece, we may say, well, it might be a nice idea, but it's not doing what we need it to do, so we're not going to allow that to go forward. Or this is working real well, let's change the rules to allow everybody to do it. I don't think there was ever an intention, other than for an interim period of time when the sandbox ends and when the new rules are passed, that would say, well, these people can go on forever and unfairly compete with the rest of the world. It was they can go on in an interim, so we don't have to shut them down while we change the rules. And if the rules ultimately don't get changed, then they would stop, then that would end it. I think that's what Adel's had in mind when we recommended this whole thing.
Thanks, Toby. That's very helpful. Judge Irma?
I agree with everything that Micah, Thomas, and Kevin stated, so I don't want to reiterate those points with any length, but I'm really concerned that the way it's written at number 6, it does put us in a position that we are asking the Supreme Court to continue to do something without any mode for regulating. I'm also concerned about the fact that this suggested 7 years, it's too long. I agree with the comments that Becky made that we do need to give some time to allow the collection of data. But I think to have the process go on for a period of 7 years is too lengthy. I don't think even 2 years that was suggested is long enough. So I would ask that we think about something in between those 2 terms. And that's about all.
Great. Thank you. Andrew?
Yeah, I was just going to say, I think we might want to consider lengthening the amount of time, maybe something closer to 15 or 20 years. And the reason why is if we have the ability to kick out folks who are bad actors, then this is all of the work that we're putting in here to even have this occur. We want to make sure that we're going to be able to get the data from it so that we don't have a situation where in the future folks end up saying, well, this factor or that factor. So I think we're working really hard. It actually is taking us more than a year. If you include ATILs, it'll be about 2.5 years, even just discussing this stuff. So I would definitely want it to go for more time than it took to even discuss it. And I think the point that Toby made around us having a period of time to ensure that the rule changes so that there wouldn't be an unfair advantage is an important one. I also think the other thing that I'm struggling to understand just in terms of my colleagues is what the danger is in terms of having it go for longer, because if we're able to root out bad actors, this could be a really wonderful opportunity for folks who are opposed to any regulatory changes to have the data to really prove out your position. So I think that the whole point of a sandbox is so that everyone can see and get the data to be able to look at and see our regulatory schema if it works or if it doesn't. And limiting it in time, I think, is problematic. So I would suggest we lengthen it to probably 20 years if possible.
Okay, Randy?
Just a quick processing suggestion. I think from all the comments I've heard, the first sentence of recommendation 6 might be separated out from the rest of it. And when this comes back, that I think has enough comments on both sides of where the timeframe should be to be a vigorous discussion just to that point. And then the latter part of the rest of 6, I think, is this exit issue. And Becky made some of the comments that I was going to make. But the adults received a presentation from Margaret Hagan that really outlined from her perspective how a sandbox is intended to function. And it's as Toby described. And when I read recommendation 6, I saw that, and this may be just my own reading or misreading, as sort of a compromise between how Toby described it and how Crispin described it. Not necessarily what Margaret Hagan described to us, but it seemed like what number 6 was trying to say is that the establishment of the sandbox would include a concept of grandfathering for participants who do no harm, but that the ultimate decision at the end of the sandbox as to whether grandfathering would be permitted would be a Supreme Court decision. So rather it being a default, you're in, you behave well, you're immune for life, you're in, sandbox ends, and if there is to be any continued activity in the absence of permanent changes in the rule, then that would be a Supreme Court decision. And if further regulation, even if it's more limited, as Becky described it, then there might be consideration of the Supreme Court saying, and your reporting responsibilities now transfer to the state bar until such time, something different happens. But I kind of read it as being sort of that either agnostic, we're not trying to commit to anything, or an actual compromise. But
So
because of that, my process point is separate the first sentence
Understood.
from the exit issue.
Yeah, so I just want to say that all of this has been really helpful, and clearly we need to redo it. So I would just say we really need to move on. So if people, we've had a lot of like, oh, I echo what, people saying, and that's helpful for us to know sort of where people come down. But if we could just really just have the last few comments, clearly we're going to be rewriting and readdressing this. So with that in mind, if some people still have their hands up, if those are just residual, could you take them down so I can see if anyone's actually truly left up here? Toby and Marta, you still have your hands up? Okay, Marta?
I'll be very brief. I think the 2-year time frame is perfect. I think that's what Utah started with and then they decided to extend it. I don't know why California will want to do anything beyond that. I think this is, as we have all discussed, this is an experiment. Let's see how this goes. Because we are going to be very judicious in how and who is entering into a sandbox and how those legal services are going to be delivered on, and we're spending a lot of time figuring that out. And secondly, I think for the, and I'm sorry I'm using the term sunset, but here we go. I think there's a lot to be discussed on that particular topic alone. And if there is a presentation that we can have or learn more on how other states are looking at sunsetting these programs and how that all works, I think we could have a more robust conversation on crafting something that would be helpful for the committee.
Yeah, I think that's a useful suggestion. Judge Sheng?
The only thing I would add to what everybody has been saying is that I think that if people are not going to be allowed to keep going, the way to address this very real concern of investors spending the time and resources in developing a really good program is to make the program go longer, to make the risk worth it. If the program is too short and they don't have any certainty for at least a certain period of time, then we are basically cutting our own legs off, I think, from the beginning. And I don't know what that time frame is, but I'm pretty sure 2 years is going to be way too short.
Thanks, David.
So based on all the conversations that we've had as a group and in the subcommittee that I'm on, I really see like 2 main threats to the utility of this sandbox. One is that it wouldn't be around long enough to produce data to answer some of the empirical questions that we want to have answered. That's Becky's point. The other main threat I see is that we would put entry requirements at the front end that are too stringent to attract the kinds of innovation that we want. And here's the problem as I see it, and maybe this is just by way of summary of this conversation, those two things are connected. Like duration, I think, in the minds of many members of this body, but also certainly in the minds of the legislature, the duration of the sandbox is going to help drive how stringent those front-end requirements are going to be. And so I guess I would urge that we try to find some kind of middle ground, because I think those two things are going to pull against one another, either again at the level of this body, or ultimately if you know, when the legislature takes our recommendation and decides to do something or not.
Okay, thanks. Eric?
One thing I was going to say just on the, I think, and I don't want to speak for John here, but I think the reason Utah extended it was feeling that they really couldn't do a proper evaluation in 2 years. So I do think, you know, the thing that caused the Utah to go to 7 and why we as a subcommittee kind of picked that was the sense of from Utah of when they would have enough data to at least begin to do a little bit of evaluation. So I just want to throw that out there as we're thinking about these timeframes, that we do have a little experience, obviously, in a different scale in a different state, where the feeling was that just was not enough time to sort of really get the data in place. So I just throw that out.
And if I can jump in here, I think we really need to end this discussion and move on to the next topic. So I apologize because I know there's a lot more we could do, but before we move to the next topic, I want to first of all thank the SAGE committee for all the hard work that brought us this far and that has us focused on some very specific decisions that need to be made. Second of all, I want to address the chat and QA features. It's been brought to my attention that the chat feature is not something that's accessible beyond the participants, the presenters in this group, I believe. And so to be consistent with the Brown Act, that means we should not be using it, because we're not supposed to be having group discussions out of the public eye. So I know nobody intended that when they put comments into the chat. For today's purposes, we will address that by putting all of the whole group discussions, all of the whole group comments that have been put into the chat into a document that'll be circulated afterwards and available to the public as we'll call it the shadow conversation from today's meeting. But going forward, please do not use the chat feature unless it's just to send a message to a specific person that you would want to have a specific dialogue with, but not to the whole group, so we don't run afoul of the Brown Act. And to those who are listening in from the public, some of you have posted in the Q&A questions for our group. While we are certainly able to look at the comments that you post into the Q&A, we are not able to engage in a sustained dialogue with those questions. The purpose of the public comment at the beginning is to allow members of the public to address the group. But once the public comment period ends in any particular meeting, we need to stay focused on the participants in the meeting being able to converse live with each other and with any presenters who've been invited. So that's why we're going to, going forward, please restrict ourselves to the live conversation and not the side conversations electronically. Okay, with that, we're going to have a brief conversation before we go to scope with two of our presenters who are one of the 4 teams looking at rules. You'll remember that in June we asked for volunteers, or before June we asked for volunteers. In June we made assignments to teams of volunteers to give us at the September meeting a quick look at, or an advanced look at, some of the rules topics that our charter asks us to address that are not specific to a sandbox. So 2 of you who are looking at lawyer advertising rules asked if you could bring to us an interim report today. And I hope everybody got a chance to review in the written materials the memo that constitutes a sort of early report from Judge Wendy Chang and Toby Rothschild on their advertising rules work. The memo goes over the fact that there's a set of April rules that was created, a set of ABA rules that was created, and that those are two of the sources, although I think there were also others, that our assignment memo asks for Judge Chang and Toby to report on. So with apologies for having to very much compress the presentation or request from Judge Chang and Toby, I'm going to turn it over to them to ask whether there is a specific issue you want input from this group on before September, when you'll be presenting more extensively.
Yes, I'll start. So the April approach, which is a total, let's eliminate everything except honesty and truthfulness, and everything else is in the comments, versus the ABA, which didn't go that far. It reduced the rules somewhat, combined them a little, but was not as extensive, dramatic a rewriting. Most of the other things we were asked to look at are variations of one or the other of those, mostly of the ABA version, that would be included in looking at that. What we really wanted to know was whether the group has some sense of how willing they are to give us an idea of which direction is more likely to be comfortable. We don't want to spend a whole lot of time on working on the ABA rules and variations of that when people really want to go all the way to what April did, or vice versa, not taking an in-depth dive into what April did when people aren't ready to go that far, which the ABA was not. They had the privilege of, they had the availability of the April reports when they did theirs, and they didn't go that as far. So I don't know if Judge Chang, if you want to add anything.
The only thing I just wanted to add to make sure that people understood that the difference between something being in a rule and something being in a comment is whether or not it is disciplinable.
Right.
So if it's in a rule, you can be charged with a violation of that particular rule. If it's in a comment, all it basically does is trying to assist you in understanding what the rule means. But if you have a rule that basically says be honest, and then everything else, it's a very broad rule, but if you look at all the other rules, they ultimately all end up in that same space, but it is broad. And so I was on the ABA when this was happening, and I was on the Rules Revision Commission when the Rules Revision Commission was doing this as well. And there's always this tension between how far you want to go. And I guess the question is, in addition to everything else that we're tackling, did you want to take this opportunity to modernize the rules all the way as far as April had recommended? Or would we do what the Rules Revision Commission was doing, was helping our rules modernize in adaptation with the model rules?
With the ABA model rules?
Yes.
Yeah.
And
Okay.
so the benefit of the ABA model rules is it's more technology flexible. Our rules are very, they're kind of a little too specific for them to be flexible that way. But beyond that, not really.
Yeah, our current rules.
Right, our current rules.
Yeah. Yeah.
So let me offer a process comment, and then I see there are already a couple of hands raised, so people do have something they want to share on this. My process comment is to say thank you for the work you've already done to frame the discussion. My goal for our September meeting is not to have the answer all set. I figure that's something we'll work on next spring, but just to do exactly this kind of framing and facilitate a preliminary discussion, which I think is kind of what you're asking for today already, in order that for two reasons, partly so that as we continue working on the sandbox, we're thinking about how the other issues we're going to be addressing next spring will address the sandbox, or will affect what's going on in the sandbox, and partly so that we just, as we go on in life, are thinking, oh yeah, this is what I'm going to be working on in the CTJG group next spring besides the sandbox, because we've been so specifically focused on the sandbox. So we don't have the time today, and we haven't gotten ourselves to a point today that I would want us to give anything like a definitive answer to your question. I don't even know that we would have anything like a definitive answer to your question in September. But there may be, as you said, some people who already have strong views, and your being aware of them would be helpful. So I'm going to ask the people who want to address this topic to do so briefly and to try to limit the conversation to, I'm going to say 5 minutes collectively, if that's doable. Kevin, you're on first.
Okay, I think I can say this in a minute. First, a reminder to Toby that the Rules Revision Commission couldn't look at the ABA revisions because they came after the Rules Revision Commission
Right.
made its revisions. Secondly, the approach of our rules of professional conduct here in California, the rules of discipline. Therefore, the meat has to be in the black letter. Comments can only be used to clarify the rules. So we can't go in the April direction. Third, what I would like to hear when Judge Chang and Toby come back in September is an argument how this is going to increase access to justice by changing the rules in however the rules might be changed. I don't see it. All that the ABA did was move around the chairs on the deck of the Titanic. They took some provisions out of 2 rules. They reduced the number of rules, and they moved those provisions into other rules, turned them into comments. And I just don't see the connection between what we're trying to do and changing the advertising rules. Thank you.
Thank you. James.
Toby and Judge Chang, did you look at what Utah has done? My recollection is that Utah combined rules 7.1, 7.2, and 7.3 in a single rule. I thought it was an elegant solution. It was very similar to something that the Federal Trade Commission recommended almost 30 years ago.
Thank you. Thomas.
Got to unmute. I'm sorry. So 2 questions to you guys. Thank you firstly for doing this, but a big part of the Justice Gap report focused on the information gap. So I would love it if you guys could say something about how these changes would inform the public as to when they might need lawyers. I mean, can we create an improvement in the ecosystem so that the information gap gets closed through advertising if possible? The other question is, it's not obvious to me why solicitation standards should not apply to email and texts and things like that. Is there a reason why email should not, that somehow that's a free zone of activity? I haven't just reading this quickly, I was just kind of like struck by that.
Because you can choose not to read the email. So the thing about solicitation is
That's
that
the
hits you
reason?
right in the face and there's no way you can get away from it. But an email you can turn off, you can choose not to look at it.
Yeah, the theory is that the solicitation rule bars sort of the power of the lawyer as a persuader when you're talking to them directly, whether it's in face-to-face or whether it's on the telephone. Anytime there's a gap between when the lawyer speaks and when the potential client receives the information, the potential client has the ability to walk away, and the lawyer loses that Svengali power over the potential client.
You could have like a barrage of email strategy, and it just strikes me as not obviously necessary to do this, but okay, I'm hearing you.
If I could just quickly add to what Toby and Judge Chang said, is that emails are actually covered. Any kind of communication is covered in our Rule 7.3 under 7.3b. In other words, if somebody or A2, I think it is.
Also C.
Okay, and it's essentially if it's going to be overreaching, if you know that the person you're sending the email to is in a particularly vulnerable state,
Right.
for example, right after a close family member has died, then you're prohibited from contacting them by any means.
Yeah, but I'm just reading this text. It says the April proposal would amend 7.3 to carve out real-time electronic communication. Did I not understand that, or?
Now that's the,
I'm gonna jump in here and
Yeah,
say, I think people have
question.
surfaced some good concerns.
Yeah.
And we do need to continue, we do need to set aside time for a substantive discussion and give our presenters time to make a more thorough presentation. So I apologize for, doing this on double speed, but I felt we needed to get in and get out so that we save at least, what do we have left? An hour and a quarter of our meeting time for scope, which is already cutting them very short. Wendy, do you have something you need to address on the issue that we just covered, or?
It was only to catch up, and my apologies. Is there a document which has the red line changes and how those connect to access to justice that I can read and not bore the rest of you with my questions about all of that?
I'll tell you what, Randy has volunteered to be a liaison for you and the other new team members in helping you get up to speed. And I'm going to let him, after the meeting, follow up with you on, for example, there are 4 memos setting out what the rules assignments are on each of these. But as I mentioned a moment ago, this is really just preliminary to get a sense of what we're going to be doing more of in follow-on meetings.
I greatly appreciate that. I don't want to waste everybody's time for things that have already been covered. So thank you.
I very much appreciate how the 3 of you are jumping into this fast-flowing river and managing to swim. Thank you all for the contributions you have already begun to make. We're going to take a 5-minute break and come back at 2:45 to address as much as we can of the scope agenda. So see you all in 5 minutes. Thanks. Ahead and take the screen sharing down. Super. Nice to see everyone's smiling faces again. And I know we're getting late in a long day, or in Crispin's case, a long evening. Thank you all for your hard work and your careful attention. I'm going to turn the meeting over now to our co-chairs of the Scope Subcommittee, Becky and Tom, to lead us through whichever one of the items on the Scope agenda you think is the best one for us to start with next. I know we cut your time off, so you may wish to do things in a different order.
Becky, do you want to go first, or should I start?
Sure, I can start us out. So we'd like to move to item G, which is a resolution that I think Mimi can show to us about lawyers who are not entitled to practice law and the kinds of participation that they may or may not be permitted to have in the sandbox. Mimi, could you pull that up for us? And the work on this was largely done, well, initiated and led by Andrew Tuft and Toby. And so if you guys want to say anything about what got the group to this point. I will also say that the Scope Subcommittee was unanimous in sending this out to the larger group. So.
Okay, I'll give it a start. Under California Rule of Professional Conduct 5.3.1, lawyers who are disbarred, suspended, resigned with charges pending, and involuntarily inactive are considered as a group, and they are not allowed to practice law. They can work in an office, but only in non-client related, research and scheduling and things like that positions. And there's all sorts of restrictions on what they can do when they're in those positions. So in looking at how we ought to bring that kind of restrictions into the sandbox, what we essentially felt was that anybody who it fits into those categories is not allowed to practice law, and so they shouldn't be allowed to make an end run around that by coming in through another kind of entity. So our recommendation is that anybody who is an ineligible person under 5.3.1, as I described it, can't be involved in the sandbox in any way. I think, if I remember correctly, Utah allows them to be involved as an investor of less than 10%. We wouldn't even go that far. We'd say if they're in that ineligible person category, they're not allowed to participate.
Thank you. So do we have discussion, comments, questions?
Or a motion? Or are
I'll
you not
move-
looking for a motion?
I'll move to approve.
I think Mary might have a question. She has her hand up.
Sorry, I just have a question. My understanding of the rule in California is that disbarred attorneys may be involved, like in a law practice. They just can't practice law, and there are other limitations on. So if a disbarred attorney were to be in a not client-facing, role where they weren't actually providing legal services, why wouldn't it be equivalent to what we allow them to do in law firms? I'm just not understanding why there would be a big difference here.
Sure, the subcommittee did discuss that. I don't want to speak for the subcommittee. It was my recollection that they entertained that would be limited to only if an attorney was involved and that attorney were to quote unquote vouch for or say that they will supervise that disciplined lawyer. There was some discussion back and forth, and the subcommittee concluded that for policy and other reasons, it would be better just to, for the sandbox, for the limited testing environment of the sandbox, to not permit participation for anyone who's deemed ineligible under Rule 5.3.1 in California, as well as the only thing I would tag on to what Toby presented is the phrase also if they're disciplined in a similar manner in any other state or jurisdiction. So they did discuss that, Mary. They concluded not to allow for the Rule 5.3.1 attorney oversight component.
That gets that, if you look at 531, it gets very complicated because the lawyer who's overseeing it has to file a document saying I've employed this person, and then has to verify that they're only doing the permitted things. And then if the person leaves, has to file another document saying they've left. And I think we thought that for the purity of the experiment, if you will, it's a limited number, a limited scope. We should just make it absolute.
Okay.
And the other, I think you're persuaded, but the other thing to consider is that regulatory function would be performed by the state bar. Right now, we're envisioning another regulator other than the state bar to be conducting regulation of the sandbox. So it might get, it's not impossible, but it would get a little more complicated.
So if there are no further input from the group, I think we have Toby's motion on the table, although I may have just taken Justice Tucker's job.
I had deferred it to you, so that's quite all right. If you want to get a second and call for a vote, I'm ready when you are.
I think I can technically second. If so, I do.
Then we have a motion on the table.
I don't want to preclude the vote. I did see Neil and Judge Asbury's hand raised. Were you attempting to make a motion or a second, or did you have a question?
No,
Toby made the point I was going to make. So,
and Judge Asbury, did you have a comment?
I was just going to second the motion.
Great.
All right, then. I suppose we have to have a roll call, don't we?
I think, Andrew, do you have a, sorry.
Yeah,
we got last second hands.
Sorry, it's a quick question. Is an ineligible person someone who gets disbarred? Are they still allowed in the state to own and get profits of the law firm that they might have started as a founding partner on?
I think the answer is no, but I defer to my legal ethics colleagues here amongst the group.
I don't believe they're allowed to share fees because they're an eligible lawyer.
That's right.
You gotta be eligible at the time. Yeah. There is case law on that.
Thank you.
Yeah, yeah, there is a reference to it in the rule.
Okay, Mary, I see you have a hand raised. Is that vestigial?
It's vestigial.
All right, then let's ask Mimi to call the roll and see whether we have agreement on this recommendation or not.
Okay, the motion is to approve the recommendation as drafted on the screen. Marta Alkenbrock,
Yes.
Andrew Ruda,
Yes.
Judge Irma Asbury,
Yes.
Mary Baldwin,
Yes.
Judge Wendy Chang,
Yes.
David Engstrom,
Yes.
Bridget Grammy,
Yes.
Tom Green,
Yes.
Dan Grunfeld,
Yes.
Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
Yes.
John Lund, Kevin Moore,
Yes.
Wendy Musell,
Yes.
Kristen Passmore,
Yes.
Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman,
Yes.
Patricia Scutiero, Satya Steinberger.
Yes.
Thank you. The motion carries.
Thank you.
Thank you. Tom, do you want to take us to the next item, which would be F?
Yeah, so this is primarily a report, but what we'd like to do is to get your input. This is very much a work in progress. So in your materials is a draft Sandbox application. If you turn to that, and Mimi, maybe you can bring that up and I'll just give a brief background. Kevin and Marta just did a very nice piece of work for us, and you see some of it in the materials. And basically, the perspective that was shared with our scope group was that there are some detail that basically the Utah application asks very big and very broad questions, but we were much more comfortable in adding to that a lot of the questions that were in the Arizona app. So those tend to be more detailed. So this is essentially a weaving together or a synthesis of the two applications. It's not completely finished because there are some bits here that are inconsistent in the sense that by bringing one thing in, we should have excluded something else. But so we're going to walk you through this. The first bit, which is essentially the first page here, which I'll briefly go through. And so this asks for basic information about what's your business, where is it located, who are you, what kind of a business entity are you, all those kinds of questions. Towards the bottom is a policy question, which is going to be more fully discussed when we get to H, which is the question of what kind of people, or basically the who question, who should fill this out in the additional detail that we've added. So this language down at the bottom, there's a footnote. So look at the text there. It's authorized person. So that this bit was taken from the Arizona application, and Arizona defines what an authorized person is. And Mimi, if you go down to the bottom with the footnote. So this is the Arizona definition of this. So essentially, you've got two kinds of folks here. Subsection A is people that own 10% or more of the entity. So it's an ownership kind of question. The second one appears to really focus on who controls the entity. So when I saw this, I think of this as, like a control entity that would be able to bind a corporation, for example. So these appear to be like a general partner, essentially the controller, the high level managers. So in Arizona, authorized person fills out this application, and the authorized person is either someone who owns 10% or more, or is the person that runs the business. When we get to the resolution, or what's framed as a resolution later in this conversation, I'll extend that list, because our general discussion within scope was, though one could require this of everybody in the business, it probably makes more sense to just do the people that really either own it or have some significant management role. And that's that. Let's go to the next page, Mimi. So these are questions 1.2 and 1.3 are drawn from the Utah application. These tend to be much more general, and a controlling person, similar to Arizona, is basically a 10% or more owner. I'm sorry, yeah, the financing person, 10% or more. 1.2 speaks in terms of someone who wholly or partially directs the management or policies of your proposed entity. This appears to be akin to the language in the Arizona definition of authorized person, subdivision B. There's an additional one, but so this is the first set of disclosures, and the policy question that we're still focusing on in scope is to whom that obligation will apply. So are there any questions on that? Okay, let's turn to Becky. And Becky, why don't you take over with respect to these descriptions of this proposed service offering?
Thanks, Tom. So that section 1, whatever it becomes in the draft that this group proposes, is who are you? And section 2 is what are you going to do? What is it that you want to do from the perspective of providing services? So it asks you to tell us how you're going to do it. So who's providing legal services, how consumers are going to access them, what the service is going to do for whoever accesses it, and ask you to describe who you're targeting. And the examples that are listed there under 2.2 are taken from Utah's application. But of course, they could be different examples. And the examples that this application, California's application, would use would reflect policy decisions that we haven't made yet about what kinds of entities and activity are permissible. What are you going to do? Who are you going to serve? What kinds of areas of law are you going to do that in? There's an example of permitted categories here. They come from the Utah application. Again, whatever they would be on a California application would reflect some kind of policy decision about what would be permitted in and what would not. Do folks have any questions about sort of what are you going to do? This part of what are you going to do?
I think Sasha has her hand up.
I'm terrible at monitoring these things. Sasha, please.
I'm missing some background on this. I just had sort of a general question. Some of this language looks like it's anticipating new entities primarily, and it sounds more corporate than nonprofit. And I'm just curious, could it be existing entities, existing nonprofits? Is it supposed to apply to all those situations?
I think the sense of the scope group was yes. It could be an existing organization proposing to do a new thing, or a completely new organization proposing to do a new thing.
Yeah, and further to that, if you look on the first page, about the middle of the page, applicant is applying as and two of the choices are nonprofit California, nonprofit non-California. So the hope is that, essentially what we're trying to do, this is the application, it's informational, just what kind of a business structure are you? So at least that was the first effort, Sasha, to suss out whether it's a for-profit or nonprofit.
So it looks like we have some input from Micah.
Just a question, thank you. The categories in 2.3 are so broad. Are we going to be giving them options on how to drill down in these categories? Because it's there are many legal issues, for example, that the term discrimination covers. or employment.
Thank you. That's a great issue for the scope committee to consider when it revises this based on this conversation. Yeah.
Yeah, we just put these in, Micah, just because we could pull them in directly from Utah. But there will be questions coming up about specifically what it is are you going to be doing, and this is just to put them in very broad categories. And just to speak to a point that was raised in the public commentary portion, this is still the application, so we're not even sure that this group is going to broadly say we could have these kinds of organizations doing employment law, for example, or whatever. So that's an issue that needs to be addressed separately. So this is just informational.
Okay, thanks.
So it looks like we have input from Wendy.
Just had questions in the application process. Will there be evaluation of some of the issues, for example, that our speaker raised in AI ethics and bias issues or waiver of constitutional rights? And also whether there's conflict of interest issues, financial interest. What I'm thinking of is a concern about Sandbox participants being on both sides through subsidiaries of a legal issue, which would not be permitted, obviously, in our current rules. So those are some of the questions that I wondered, are we going to be delving down on those in the application process or at some other point before those folks are allowed into the Sandbox and start participating?
That's a great question. I'm gonna bounce part of it to Tom, but I should have, when we started this, we maybe should have put it into context, which is this application is what is asked directly from the applicant. And some of what you're describing would absolutely fit in there. And I think some of what you're describing might reflect policy decisions that would be prior to someone applying. Tom, I don't know what you want to add there.
Sure. You might take a look, Wendy, at the bottom of page 3. There's a 3.0. I mean, you can get to it later, but basically this says why, how is it that you're eligible? What are the rules you want us to waive? So if somebody was going to, in order to run their business, enter into arrangements that would create a legal conflict within the meaning of our ethical rules, that presumably would be disclosed here, which would be one point. And then on the next page, and this will challenge us a bit on the scope committee, but the next page harks to a Utah question, which is fully and candidly discuss the risks your customers would face. So presumably a conflict of interest would be a kind of risk that they would face. Our hope is that in combination with the SAGE group, we can come up with a list of more detailed kind of questions to surface these risks. And that would also be a place where some of the AI and dark pattern stuff could come in. And I'm hoping that we can find some language to probably put somewhere near this or under this as sub portions. So those would be my perspectives on that.
Can I address a couple of those of Wendy's questions and comments? And I think Kevin can probably jump in here too. When Kevin and I were looking at the Utah application, we then contrasted it against Arizona's, and we found Arizona's was much more in depth. And it asked a lot more questions with respect to who is involved in the organization. Is it a corporate entity? Where is the corporation headquartered? Is it in good standing? Who are the shareholders? I mean, there's a lot of questions that the Arizona application had that wasn't present in Utah. And Kevin and I were much in favor of a much more in-depth evaluation in the early stages of the application process for those types of disclosure that could root out some of the conflict of interest areas that could be a flag of some kind, red or otherwise, to the Sandbox regulators that are evaluating the application. on the front end. And Kevin, maybe you can speak to more of that as well.
I agree with what Marta said. We were seeking more detailed information. But I think that can be added because we're talking about this generally. And I think the subcommittee has to roll up its sleeves and maybe discuss this and come back and present it as to what the more detailed questions might be. But one thing I was thinking of, given that we're looking at the delivery of reasonably priced legal services, at least to a certain extent, perhaps we should have a question here specifically asking the applicant to address how they anticipate they're going to, what's the word that you economists use, scale the services to increase its availability and make it reasonably priced for people. So it's just a suggestion that we might want to add a question like that to have them think about it. And also a question, what is their strategic plan? I mean, do they have a strategic plan and can they attach it? Ask them for how they intend to scale it, and they hopefully will have some kind of a strategic business plan that they would be able to share.
Thank you. It looks like we have input from Crispin.
Thanks very much. I just want us to be a little bit cautious about what we ask for. What would we do with the information that we get? If we receive people's business plans, their risk register, their technology model, what are we going to do with that? And what expertise would we ever expect a regulator to have? And what responsibility are we taking away from them to own the ethical obligations and transferring onto ourselves? So what I mean by that is it's much better to be clear that there's no reason to not let somebody in and remind them of their ethical obligations than it is for us to try and pre-approve and check. Because if we pre-approve and check, we will misunderstand, we won't see the detail, and like any plan, it doesn't really survive contact with the enemy anyway. Yeah, once they get into market, what they're actually doing will evolve and change and develop, and our pre-approval of the detail will be a false comfort for us and a false comfort for them. And it's much better to say, we've approved you as capable of behaving ethically, but it's your obligation to understand your ethical obligations and stick with them day in, day out. And we will take action against you, enforcement action against you, if you breach that. So I'd be very, very cautious from the experience of doing this for 10 years in the UK, very, very cautious of trying to solve every problem by pre-approving a new entrance approach. It won't work.
Thank you. We have input from Wendy.
One of the new regulatory models in California that's very robust actually is the cannabis regulations. If you look at those applications for various types of business entities, they have different applications for different business models depending upon what you're applying for. And it's very robust. They do background check, they ask for your driver's license, etc. They provide a whole load of information. And as far as I know, that has been and others may know a lot more about the regulation piece and the enforcement piece, but the fact that folks were required to provide very robust applications, including their business plans, including safety plans. I mean, they go into a great deal of detail, has not foisted people out of the marketplace. And so it may be worthwhile looking at some of those applications. I know this is apples and oranges to a certain degree, but that is an example of recent regulation of a new type in California that is extremely robust, and yet it hasn't affected the marketplace.
Thank you.
Yeah.
Eric.
Just to kind of follow up on something Crispin was saying, but is this going to be public information? Or is some portion of it going to be public? Because I guess my concern is if we're asking for a lot of information on business plans, that may be something that's proprietary. By contrast, I can see reasons why who owns this, you would want that to be public information. So in terms of the information we're asking for and kind of whether or not we're going to make it available sort of publicly, we also might want to think about the scope of what we're asking for.
Great point. Thank you. We have input from Micah.
Yeah, thank you. I think that's a great point in terms of whether or not the information is public. I can't imagine that most of the sensitive information would be made public, just like in our disciplinary system, that information is not made public. And for the non-lawyers, I do just want to remind all of us that the first prong of the State Bar's mission is to protect the public. So when we, as a committee of the State Bar, are coming up with an application, I think we have to have that in mind, and any information that we can find out and keep confidential about the background of these companies who are, or entities who are applying, that would help us protect the public. I think we need to find that information, verify that information before we consider letting them in.
Thank you. I think we can move to you, Tom.
You mean 2.4?
Yes, yeah.
Okay, so the question on the table with 2.4 is describe your business model. You want authorized in the sandbox, including the management structure that will oversee this provision of a service. And then the stuff which is not bolded, unfortunately, describe how the governance structures and policies will ensure that, and then there's a list. So this is a straight pull from the Utah text is the bolded information at 1.2. The rest is from the Arizona application. So one of the things that's a little, we as a subcommittee need to work through this. Partly it is our goals and objectives, maybe some version of the mission statement sort of lands here, but I just wanted to reference something. There's a footnote 2 that we inserted, which references this, the Arizona structure creates alternate business structures. And then if you come into that regulatory entity and you want to set it up, think of it as 2 boxes. There's the big ABS box, but if lawyers are within the box, there has to be a compliance attorney who makes sure that the attorneys within that interior box follow all of the Arizona ethical rules. So that explains why, if you go up to the top again, Mimi, this language about the first one, providing legal services, lawyers providing services with independence, and then the last one, the firm will not interfere with the lawyer's duties and responsibilities to clients. So that we have not reached that point. We've not talked at a high level about ABSs, nor what an ABS might look like in California if we want to go down that road. So this touches on the Arizona model. That's something we're going to need to discuss, and this is something the subcommittee is going to have to work through, but just be aware of that. And then I think, Becky, you've got the next 3, I think, 4, actually.
No, I just have the next one, your consumer data.
Consumer data. Oh, I'm sorry. Sorry.
To Andrew Aruta's point earlier about settling on the mission of the sandbox, there are, of course, many pieces of this that are still open, but 2.5, which is just above what you can see on your screen, asks you to describe how what you've said you're going to do advances whatever we decide the regulatory objectives are. So we've decided the purpose of this activity is XYZ. How is what you want to do going to be promoting XYZ in the world?
Right. And then I think that brings us, I'm not seeing any hands here, but That brings us to consumer data. So what we've done here is melded portions from Arizona and portions from Utah. The first one, 2.6.1, does your business model include the sharing or selling of consumer data? That's one of the issues that really is much on the mind of many sort of privacy-oriented consumers. 2.62, describe your policies and procedures regarding the use of clients' confidential information. And then 2.63, it asks for a description of how the firm will protect consumers' information and privacy, and also protect consumer data from unauthorized disclosure. So the hack problem and then the internal use problem are both covered there. So those are the consumer data ones. Questions on that?
Looks
Okay.
like Mary has something to say.
I just have a question about 2.6.1. When we ask about business model, we mean specifically with respect to the activities that are sought to be proposed, to be offered through the sandbox.
Yeah, I mean, conceptually, what I would expect us to be concerned about here would be part of our business model is to sell your private information that you're going into bankruptcy to a credit card company that provides a service at a high cost to potential bankrupts. I mean, that kind of there's money to be made in selling or sharing information. So I think we need this basically would suss that out.
But I'm asking, some entity might have a large, business model that includes a number of different, sub entities, and the sub entity that is offering services through the sandbox. I mean, are we just intending this question to be asking just about the sandbox?
Yes. I mean, at least, that's my view. I mean, for example, with Google, which obviously sells people's private data, it, sucks it up in great volumes and then sells it in various ways. If they were to spin off a legal tech firm, the question on the table would be, what does the legal tech firm do with the information it secures or obtains from its clients or customers in the legal subsidiary? That would be my sense of it.
And I'm not sure that question is specific enough. So just as we roll forward, we might want to, and it seems to me that what you're asking also would come in from the answers to 2.6.2 as well as 2.6.3. So just a suggestion.
Okay, got it. Yeah.
David.
I just wanted to note that this is, I think, something that if we have time, we'll talk about during this session. This is something that Kevin and I have been working on, duties of confidentiality and
yeah.
security. And I do think this is yet another place in the application where its precise framing will turn on policy decisions we make elsewhere in our process. I personally think, just to front my view, I think we probably should prohibit commercialization of data. And if that's true, then 2.6.1 is out the window.
Yeah, there are certainly those that would join you in that, David, for sure. But that's the consumer data portion so far. And Becky, I think back to you for 3.0.
Yes. So then the next question asks whoever's applying to explain why they need to be here. So what are the things that you're doing that you couldn't do outside of the sandbox, and what rules are preventing you from doing those things? Mary, did you still want to say?
No, sorry.
Okay. Judge Wendy Chang.
So I had two questions on this one. I think the first one is, so are we expecting people who are applying who may or may not be lawyers to really understand this aspect of it? And I guess that kind of pulls into my other question, is I would suggest, instead of saying are not permitted, I would say may not be permitted. Instead of are, use the word may. The reason I would do that is because from my perspective, from what I was doing before I was appointed to the bench, there was a lot of business people coming to me with things saying, is this okay? Is this okay? And there's a lot of times you come back and you would say, well, there's this risk. I couldn't give a yes or no answer to a lot of those questions. And so the whole purpose of this is to basically bypass that question and say, look, You're going to be safe regardless. It might be okay now, it might not be okay now, but if you enter into this process, you're okay. I think if you go into the are or may, I just don't think it's a distinction that needs to be made. And I also think that there may be a category of person who would be not comfortable in answering that question, because if they don't get authorized and they've got something similar, you've got to, I don't know, to me is evidentiary. It might be evidentiary, and I would have a problem with that as their lawyer. If I was advising somebody who is applying something like this, I'd be very nervous answering that question with an R versus a may.
Thank you. Both great points. If there's no further input on 3, we can.
I mean, I guess, was there an answer to the question? Are we expecting people to get an ethics review?
Again, I would say that would be a policy decision that would be reflected in the application if that's something that we decided. But what this application is simply asking is for information that the applicant can themselves provide. And you raise a good point. If I'm not a lawyer and I want to deliver legal services, will I be able to do the legal analysis to tell you which laws I'm violating?
Yeah, I mean, I think what was expected here, Judge Chang, was, we need a waiver of the fee sharing rules or the anti-solicitation rules. And we as a subcommittee, we discussed, albeit briefly, including the most significant 5 or 6 of the rules that probably people who apply are going to want to touch base on. But it was the point, what we're trying to do is separate or distinguish between the folks who, if they actually knew what they were doing, could do what they want to do without getting the waivers, versus the people who need waivers. And then if they list them, then we're going to have a much better understanding of their business model. So I need a waiver of the conflict of interest rules, for example. Well, that's interesting. So, this could be a pretty important question, although it potentially could be more precise. And I would assume, by the way, that these people would be advised by lawyers that would have at least a general understanding of the rules of professional conduct.
Mary.
I just want to echo Judge Chang's comments. For those of us who, are legal ethics lawyers and who have advised innovators, in the space, there is no clear, bright line rule. And what Judge Chang described as, yeah, there's a risk, but maybe you can do it, is about the answer that, we have to give, because there's just not a clear guideline. So, but to your point, Tom, it's very important to know what rules or statutes the applicant thinks, that they are seeking to be waived for their business. Why not just ask that rather than asking them to make an admission about the legal effect of their current or proposed activities to reach a legal conclusion about that, which, I mean, you're in.
Oh, I see what you're saying. Yeah.
So anyway, I would really propose that, because we could talk for a long time, but there are the rules around this. Maybe they're clear at the edges, but in the large majority, it's really hard to know what's permitted and what's not.
That seems fair to me. Kevin or Toby, you guys have thoughts on that? That seems like an easy lift to me, but sounds good. Thanks, Mary.
I guess I could just make one quick comment, and that is that presumably these people are going to be practicing law in one way or another, and we would assume that they would know the rules and understand the rules. If what we're saying is, well, you don't have to know all the rules, we expect lawyers to know those things.
Well, I could just tell you from the lawyers who came to me, sometimes they really don't. You think they do, but they really don't. Especially not in this context.
But more than that, it's not about understanding the rules, Toby. I understand the rules, but when I go to analyze a particular, business model, and I'd invite you to do the same. I can't say definitively that in a lot of cases that it violates the rules. Sometimes, yeah, but sometimes no. There's not a lot of guidance.
I understand.
Kevin.
just the point I wanted to make, I think Toby already made to a certain extent, that they should have some idea what their business model is. But I think this question came from the Utah application. So why don't we ask Utah as to how the question's being answered? And we might find that it's not an issue, that people know darn well when they come in. They have a business plan that they've thought through. They were aware that they couldn't do it before, and now they want to test out this particular business model that they have and not be subject to regulation, not be subject to criminal prosecution for unauthorized practice of law.
Well, having reviewed many of these in Utah, I would say they don't have a difficult time knowing that what they want to do is share fees with non-lawyers and that kind of thing. I would also go back to a point that David often makes in our subcommittee, which is that the application is like the first communication from the applicant to whatever entity is going to read these things. And then there'll be some iteration back and forth to make sure you get what that entity needs to make its decision. And so it may not be as necessary to imagine upfront the precise way to word the question to get exactly the information that you want, that we feel right now because we're so isolated from that real process. So if there's no further thoughts on this, I think we can move to 4, which is risk assessment. This comes straight from Utah. So the first thing that the applicant is asked to do is to fully and candidly discuss the risks that consumers might face if they use your service. And then this model of regulation will be focusing on some set of risks. So we would say including the following. Then having identified what you as the applicant see as the risks, the applicant then is going to describe specific ways that they are going to identify those risks, track them, and mitigate against them.
I'm not so clear on what the middle point is, track risks. Are you talking about as a sort of statistical matter, or are you talking about following an individual case through?
Well, my recollection from the subcommittee's discussion was that we felt like these were conceptually 3 different actions. So one, how are you going to know if this is happening? How are you going to measure, identify, recognize it's happening? And then what are you going to do to prevent it or deal with it once you notice that it's happening? Dave, I think this was David's language. He may want to add something here.
I got nothing. Sorry. I do remember that conversation, but I don't remember what we meant by track as against mitigate. Maybe it's worth just a little bit of discussion right now. Maybe there's a way to make it more clear.
Yeah, well, why don't you let us scriven with this a little bit? My recollection of this was the idea that once you've identified a risk, you need to monitor it, and then once you see that the risk is being incurred, that you would then go into a mitigation mode. So, saying that there is a risk without monitoring really doesn't help the consumer out very much. So I think that was the basic idea behind 2 as one of 3.
I think
let us play with it.
We have input from Wendy.
I wondered if it might be helpful to identify what we mean by risk, some sort of definition or examples of what might be areas of potential risk within a catch-all area, because I can foresee that applicants would say, risk, what risk? We're fabulous, everything's great. Or, we have proper, we're not going to get hacked or something very obvious. But it may be helpful to get substantive data if we provide what we mean by risks and perhaps categories of risk with then a catch-all, maybe something we wish to consider.
No, that's an excellent point. And the SAGE committee is working hard on identifying the risks that the sandbox would be focused on, but you all did such hard work on item A that we never made it to item B. So that's definitely on the table.
So can I jump in and just make a quick comment too? Because I'd certainly beat the drum about that these application processes are going to be iterative. And so we should think of this as like an opening opportunity to engage with an applicant. I'm sorry, I lost my train of thought. Sorry, folks.
Maybe it'll come back to you. Well, I'll call out the last thing here, and this was, and I'm gonna call out Justice Tucker because she suggested it was important to have the complaint process described separately.
It's back, Becky. So the other point I was going to make is that something we've discussed at the subcommittee level was that if we prime the applicant with too many examples of the sorts of risks that we're worried about, then you worry that you crowd out more open-ended, critically reflective thinking on the part of the applicant. And so, when we talked about the subcommittee level, I always thought of the interpretive canon of expressio unius, where, if you state a bunch of things, then that necessarily implies you're excluding other things. And so we worried a little bit about that. That's an instance where an application that's too fulsome in its articulation of lots of things could end up crowding out information and then impairing what we think will be an iterative process. So what we want is an application that's going to raise the right flags so that the regulatory body can ask further questions and follow-up questions and really smoke out concerns.
We have a comment from Crispin.
Thanks, Ken. I just want to come back to my concern about asking for too much and what we do with it. And, we could put these same questions to lawyers setting up traditional law firms. We could all identify risks of things that go wrong. And we know from the disciplinary records that they do go wrong, but we don't, because we set out clear standards and we expect them to comply with those standards. So again, just a caution about asking for this stuff up front as part of an application. And I wonder if one of the things we've got to think about is separating out what's the information we need to approve you coming in, what's the before the event stuff that you must get over the hurdle, you're not a disbarred lawyer, etc. And secondly, what's the information we want from you in order to be able to supervise you effectively and for us to evaluate the impact of this sandbox. And separating them out helps us be clear why we're asking for some of this information, rather than drowning ourselves in stuff that we would never ask a law firm when the risks are actually very similar in a traditional law firm.
Great point. Thank you. All right, I think that takes us to 5.
Yeah, so this is a combination, actually, explicitly of both Utah and Arizona. So the first one, 5.1, is, does your proposed offering comply with California Sandbox rules? So that would be some thought that, within this, we're going to create this regulatory structure. Does your proposed activity fit within that structure, assuming you get the waivers that you want? Becky knows this. I've been kind of going back and forth. I'm not sure this adds hugely, but there's a constituency for this. The rest of this, 5.2, which goes for almost a page and a half, this is a straight lift from Arizona. And so take a look at this and get back to us. But this is really an effort to collect information that may bear on, whether you are a person we can trust to serve other people in a, in this kind of a role. So, have you committed any material misrepresentations or frauds, and goes on. But this is a straight lift from Arizona. And I think there wasn't huge conversation about this within scope. I think our group pretty much liked this list. But so you will probably see substantially the same list coming back to you when we come back for final approval, but certainly something to take a look at. On the last page, just to go to what's numbered 24, which is at the top of the page, one of the things we ask about is, have you failed to respond to a request to supply information that was legally requested by a regulatory agency. So we really are trying to be very careful about responsiveness to regulators. And then the last bit of this is explicit direction with respect to any criminal matters. If you indicated, for example, that you had been prosecuted and convicted of a felony, then you've got to provide information about that conviction, when it was, what it was, all that kind of stuff. And then 5.3 is an effort to reach out to other jurisdictions in which the firm operated. So I am presuming myself that most of the applicants, at least the early applicants, are currently operating in other jurisdictions. So this is going to give us a lot of information about who they are, what they are, and that sort of stuff, and will give our regulator information it needs to be able to contact folks that are already regulating the entity. But that, I think, is an important set of inquiries. But that's essentially
Can I ask
where
a
we are.
question about 5.3?
Yeah, sure.
Is it where the organization operates or where the organization provides legal services, which may or may not be the same thing?
Oh, good question. Yeah.
I think Toby also has something to say.
Yeah, Toby, please.
Yeah, I just wanted to comment that it was, the discussion in the group was that listing all these terrible things that you've done in the past is not exclusionary. And if you answer yes to any of these, you're out, but this raises a question for further inquiry. And that's part of the iterative process that David was talking about, and making sure that we don't exclude somebody that, yes, the answer is yes, but it was 20 years ago, or, whatever, that we want to know the information as part of a background check, but that it's not intended to, rule anybody out automatically based on the application. And
yeah,
I think that needs to be either clear in the instructions to the application or somewhere, so that people understand that.
Yeah, and I think one of the things that Scope needs to endeavor to develop is a standard, because these are going to be involving, with all this information, how do we decide whether somebody's out or in? Is a 20-year-old felony that big of a deal, or what kind of felony was it? I mean, I think we need something that we could probably lift from the state bar's moral turpitude standards, but we will need to provide some basis for using this information in a out-in kind of way. So, I mean, that's a work product that we still owe folks. And with your permission, Justice Tucker, I'd love to go to
Tom. We have just one last comment on this, I think, from Neil.
Yeah, just really quick. This list that of 23 factors, right, that's in this application. It's lifted out of Arizona, but it's also specifically the same list that is in the regulations that the Arizona Supreme Court passed, saying that these factors can be a reason why the applicant's denied entry. So just a FYI point for you folks.
Oh, thanks, Neil. That's very helpful. Yeah, thanks.
And we do have one more comment from Satya.
Hi. I might, again, be not up to speed on this, but I'm just curious, if I were looking at an application, the things that I would want to know would be like what the value add is. I see a little in 2.1, but what the real value add is and how non-lawyers are well equipped to provide that, and what holes this service is filling for low-income communities who don't have access to the legal system, and what the fee structure is. So I'm curious, like, does that come later? And, what's the thinking around some of those kind of questions?
I think, well, first, I think these are very useful points, frankly. And I would love to have all this information. I think that we were kind of hoping that the generality of those questions, which were drawn from Utah, would get those kinds of things. But I think our approach here, Sasha, I think, is to leave in the generality, but include at least a few specifics, and those specifics sound quite good to me. But that would be the thought. So unless there's more, if we could turn to H, that would be terrific.
So H is the closely related topic of application criteria for the applicant background checks, the memo that
Right.
provided in the materials.
So to the extent you guys could give us some guidance, this would be very helpful. So just by way of background, I think the approach, although it's not completely finalized in scope, is that the disclosure requirement would be limited to a subset of folks. And we've gone through and surfaced, or I have anyway, what appear to be the various persons that Arizona or Utah sought information from. So if you look at sub A, it includes authorized persons, and I'll walk you again through that definition. Compliance lawyers, there's a big if here. If we were to include a requirement for compliance lawyers, that is people who would make sure that the local ethics rules are followed completely, then we're saying, I'm suggesting that this should be a disclosure. Managerial persons, that is folks who are more supervisors, and the definition I use is really from Utah, which is if you supervise people that provide direct services, you should be covered. And then Arizona also requires a principal, that is a person, a specific person that would be their contact with the entity. So those are the four kind of categories of people that at least I would suggest to you, and that Becky would suggest to you, probably makes sense to be covered by this. So the policy issue, probably there are two policy issues. The broadest is we would not have everybody in the entity, which might be 50 or 100 or 1,000 people, do all of these disclosures and thus have to go through them. So it would be a relatively small subset. And then the second policy question, which we'd love guidance on, is whether these folks are the right ones to be required to give disclosures. So just a reminder, authorized person is somebody who has 10% or more ownership, or has a legal right to exercise decision-making authority on behalf of the Sandbox entity, which feels like general partner, CEO, folks like that. Compliance lawyer, and this is drawn sort of a paraphrase of what's in the Arizona rules, means an active member of the State Bar of California in good standing who, pursuant to the rules, shall be responsible for ensuring compliance with all applicable laws and rules governing Sandbox entities. So that's a lift from Arizona. And then decision-making authority, that's also a lift from Arizona. Essentially can legally bind the Sandbox entity and like that. The term principal is this contact person. And finally, a managerial person. This is another lift from, this is a lift from Utah, means somebody who manages or supervises the direct provision of legal services within the firm. So I know that's a machine gun of language, but we'd love your input in terms of, firstly, the broad question, should we be requiring these disclosures from a small subset or everybody? And if it's a subset, does this sound like it's in the ballpark?
Looks like Toby has a hand raised.
Toby.
Residual.
Well, Kevin has a hand raised.
Yeah, just quickly, I'm sorry. Could you restate the difference between managerial and principal persons?
Principal is a contact person. So think of that person as the ambassador to the regulator. They would be responsible to the regulator for responding to their requests. I mean, conceivably, if you had a compliance attorney, it could be the same person, but the Arizona structure contemplates a specific person who would be responsible for responding to the regulator.
Okay, thank you.
Can I offer a comment in response to that? And this might be in the way of a suggestion even. I see a fair amount of potential overlap in these terms you've gotten from different states, the compliance lawyer, the principal, and the managerial person. What if we were to say that the first category, your category A, authorized person, is one category that you need to disclose. And the second category you need to disclose is the person who is either your compliance lawyer, or if you don't have a compliance lawyer who is in charge of provision of legal services, let's call it other managerial person, which is to say the non-lawyer who's in charge of legal services. But either way, we're saying you got one person who's in charge of the provision of legal services. Either that person is what one state calls a compliance lawyer, or it's what another state calls a managerial person. And wouldn't that person sort of automatically be the contact person who we would also have serving in the role of a principal, so we don't even need to designate a separate person called a principal?
I think actually that makes complete sense to me. I mean, it's just sort of interesting to me looking at the Arizona application structure that they broke it out this way, because you'd think the person if you were a regulator and wanted to contact somebody, it would be the senior person or the compliance person. So yeah, I think that makes a lot of sense.
David.
This is piggybacking a little bit off of what Justice Tucker just said, but how do we prevent managerial persons or person from covering anyone above the line level, anyone above like the street level provider? Like if you think about a law firm, like a heavily leveraged law firm with partners and then lieutenant partners and then a layer of partners below that, and then a set of associates and a set of associates, like technically everyone except for the first year associate is a managerial person according to that definition, I think. So how do we avoid that, where you just have, managers all the way down except for that line level? And the problem, of course, is that you could go with a compliance lawyer at the top, and that's a single person, and that feels clean, but that can get really attenuated in a fairly large operation. So, you actually do want some managerial persons in the mix there, some kind of mid-level managers, as opposed to the top dog who may not be aware or may not have the capacity to exercise real managerial control over everyone who's providing legal services.
Yeah, I think yes and no. So I think getting the person at the top, which I think it was kind of like the control group, in evidentiary terms, and getting somebody who is the one that supervises the paralegals or the tech people or whatever, I think that's useful. I think this may be a language issue, because I think we're pretty close conceptually, but I may be wrong on that.
Kevin.
Yeah, I was going to make the same point between our Rule 5.1, our Rules 5.1 and 5.3, distinguish between managerial lawyers who are responsible for supervising and implementing policies in a law firm, which is very broadly defined in the rule, and supervising lawyers who have direct supervision over particular people. So I think we need to draw that distinction.
Do you think this is a little unfair on the fly, but do you think I can just pirate the language from 5.1 and 5.3?
I hesitate, because whenever I've tried to pirate language for a different use, it's never really.
Okay.
But it's for a discussion draft. I think you can.
Okay. I'll look at those again. That's helpful.
Okay.
Neil.
Just to be clear, just raising the question about whether or not there may be similar terms already defined under California law that we could actually refer to, as opposed to borrowing something from Arizona. Just raising that as a possible question.
I think it's a great question. Do you have any instincts that there may be stuff like that around? 5.1, 5.3, those concepts are clearly there, but do you know if it's someplace else too?
I do know that when corporations are renewed, in terms of keeping their licenses current, they do have officers and owners, and they have those different boxes that you can check off when you're trying to renew those licenses. So I don't know if that means there is a hardened definition of what an officer or an owner is, but just flagging that is something maybe that's worth looking into.
Yeah, I think that sounds good. More suggestions, comments? So Becky, what do you think? Are we at the end of our trail for this part of the report?
I think so. Thank you, everybody.
And I think that, to you, Justice Tucker, I think we're at I in this wonderful memo from David and Toby about attorney-client privilege, confidentiality, et cetera.
David and Kevin, I think.
Oh, sorry, David and Kevin. Sorry, Kevin.
And Kevin's on mute. I thought that memo was excellent. So before David or Kevin wants to share anything about it, I just want to compliment them on the work and also point out that it's going the same question that they looked at in proposing alternatives. Should we generalize to non-lawyers, or should we free lawyers from rules? I think it was, you termed it, was it rounding up or rounding down?
Yeah, level up or level down.
Level up or level down, thank you. I think that same question is going to apply to a lot of issues that we're going to have to decide, not just in the context of leveling up and leveling down in the information control, but also on other areas as well. Do you want to speak briefly about the memo and the, ooh, I hope you didn't get the feedback I just did. We don't have very long to go, but do you want to start in on some of the issues framed on the last page of that memo?
Sure, I'd be glad to frame up the memo a little bit, just to create some food for thought for folks, maybe as an entry point for some conversation about it. Would that be helpful?
Yeah.
So with apologies, my first Zoom call this morning was at 6 a.m. with some East Coast lawyers with whom I'm litigating a case. So I'm close to my 11th hour on Zoom right now, but I will try to be relatively crisp and clear as I do this. So I'll assume everyone has taken a glance at the memo. The top line policy puzzle is the one that Justice Tucker just noted, which is that confidentiality, data security, and privilege are already regulated for some entrants to a proposed or to our sandbox, but not others, through a mix of the rules of professional responsibility that apply to lawyers. So Rule 1.6 on confidentiality, Rule 1.1b's duty of competence, which includes competence on technological matters, and then Rule 1.9 on use of information from past representations in a way that might be adverse to a past client. So there's that mix of rules, but then there's also the CCPA, California Consumer Privacy Act, or maybe it's, I think it's now going to be the California Privacy Rights Act as a result of the recent changes to the law. So anyway, we have this problem then that these rules are going to apply differently to different entrants to the sandbox. And so the key question is going to be whether we level up and apply them to all entrants, or maybe level down and even take away obligations from certain entrants, or whether we tolerate some lumpiness or some asymmetries in terms of the rules that apply to different entrants to the sandbox. And so that's like the top line puzzle. But then the other thing that I think the memo does that's helpful as we think about this as a group is to note that we can break down the problem into two discrete situations that are going to come up most frequently, I think, and should be in the front of our minds as a group. And then there's sort of a third tag along situation. So what do I mean by that? The first situation is voluntary disclosure situation. So where an entity or an entrant wants to voluntarily share client information. And that of course raises the possibility of commercialization, or I think someone used the term commodification earlier in our meeting of client data. So that's voluntary disclosure. That's the first one. And that's gonna be an issue we're gonna have to think about. The other one is involuntary disclosure. And of course, that's like data breaches or cybersecurity, failure to take appropriate precautions to safeguard client or consumer data. The third tag along then is compelled disclosure, and that raises a separate set of questions. That, by the way, tends to implicate attorney-client privilege, whereas otherwise, as we note in the memo, the duty of confidentiality is actually the broader set of obligations and set of protections. And so that's where a lot of our thinking is going to need to be. So in the end of the memo, then we say, look, we've got this question of leveling up or leveling down, or tolerating some lumpiness in terms of what applies to whom. And we need to think about them across these two contexts in particular, voluntary disclosure and involuntary disclosure, and we can sort of mix and match across those. If I had my druthers on the voluntary side, I think we would just prohibit commercialization outright. And then maybe level up with confidentiality. But if you've already prohibited commercialization, then the duty of confidentiality actually doesn't do much work. It kind of restricts gossip about a client, but you've already covered the main policy question, which is whether entrants can actually commercialize their data. The involuntary side is a little bit trickier because it's the same problem, but then that also, I think, brings in the CCPA in a full way. And there's some entrance to the sandbox that would be covered by that, and so I think that makes that situation a little trickier. But even there, I think we should probably level up as to the duty of confidentiality, and that brings with it lots of duties to take reasonable precautions with client data, and take reasonable precautions to protect against data breaches, for instance. So anyway, that's my way of trying to motivate some discussion. Kevin, do you want to jump in? I was much more long-winded than I wanted to be, maybe because I'm in my 11th hour of Zoom, but Kevin, maybe you should weigh in here, and then we can have some conversation about it.
Yeah, the only thing I wanted to add is something I missed that should be in the memo that didn't add in, that the lawyers owe a duty to prospective clients, even clients who the lawyers don't end up representing. So we should include that. So wherever you see rules 1.6, 1.9, I would add 1.18, put a slash 1.18. And that also figures into any discussion of attorney-client privilege, because the privilege applies even if the client never retains you. Anything that the client may have disclosed to you during a lawyer-client communication. And that's all I wanted to add. Otherwise, I thought David did an excellent job of summarizing it and setting us up for a quick discussion.
Can I ask that we hear from Crispin in that discussion? I know there were some specific questions, maybe even in this memo or elsewhere, that we don't really understand how the UK handles non-lawyers providing legal services and the concept of the attorney-client privilege. Are you able to address at all whether what we think of as attorney-client privilege is extended in any form, or are some other confidentiality obligations extended to those who are not lawyers, but who are providing what we think of as legal services?
I can certainly give it a go. So I think you've got to split the UK non-lawyer part into two. One is, if you remember one of my really early presentations about the fact that most legal services here can be delivered outside of any regulation. It's not that they're non-lawyers authorized to give legal services. They simply are not covered by legal services regulation at all. They're just bound by consumer law, fair trading law, etc. There is no attorney-client privilege in that situation. So a non-profit advice agency giving support to people on a employment labour dispute, housing disputes, commercial legal advice for small businesses or big businesses, there's no attorney-client privilege there at all. Where it is a regulated ABS, so it's authorised to deliver the list of reserved activities, the litigation, advocacy, and certain other types of legal services, and it's using the solicitor title, then the rules are broadly the same whether or not there's non-lawyer ownership or whether or not it's a lawyer-owned entity. And remembering that in our non-lawyer owned entities, there is still a senior lawyer responsible for the delivery of legal services. And that's really where entity regulation comes into this, that the client's contracting with the entity is authorized, and statute legislation creates appropriate attorney-client relationships there. So, you know, it really depends where in the market you're going, and there is variation. And what we expect of solicitors involved in different types of services is that they explain to the client what protections exist. And that really takes me, I think, to how I would approach this, particularly in a sandbox, which is we want to trial different things. So I would actually accept what David described as a lumpiness in this, that there are slightly different provisions applying in different places, and make sure we think about how are we going to track and understand that, either through data or consumer research or qualitative research in 2, 5, you know, however many years down the line, to understand how it plays out, and to be clear that we put an obligation on participants in the sandbox to be clear with their clients about how their data is used. So I wouldn't prohibit commercialization. I certainly wouldn't prohibit anonymized commercialization, but I would make it a condition of participation in the sandbox that it's explained to clients how their data is going to be used, so they've got a choice. If they don't like it, it's explained to them, they can go to a different service provider, and it becomes a feature of how the market works. And then the last thing I'd say to David is 11 hours is nothing. I've just entered my 16th hour on Zoom today.
All
All right, I'll
right.
stop complaining.
Mary and Wendy both have their hands raised. Before I ask each of them to speak, I'll note that we have already gone past 4 o'clock. I appreciate people sticking with us. I will wrap us all up by 4:15, and if you have to leave before then, we understand. Mary.
Thanks. One thing I wanted to just observe is, you know, part of the function of the sandbox is to collect data. And we haven't spent a lot of time talking about what kind of data we're going to collect. I think it's pretty clear that much of the data that we would collect from sandbox participants is going to require them to violate their duty of confidentiality as lawyers. So, and that's because the duty of confidentiality in California is very, very broad. And so I just want to point that out to say that, you know, I think that certainly there have to be protections for consumers, and but you know, anonymized data, just like the way we want to use it for the sandbox, there may be, you know, important and valid uses for anonymized data that wouldn't impact clients' rights or interests in any respect. So I would encourage us to consider a flexible approach that requires, you know, a showing of how they're going to protect, you know, the identity of consumers and you know, material information that's individual to consumers. But I wouldn't broadly require all participants to adhere to the duty of confidentiality, and I wouldn't have a broad, definite ban on commercialization.
Thank you, Wendy.
I think this is an area that is really of great concern for consumer protection. I think there's a difference between data going to the regulatory agency in order to evaluate whether this experiment is working versus commodification of client information. And I think that we all know, for example, when we use almost any electronic service, it's a click here and you're done, and there's hidden terms, you know, contracts of adhesion, where rights are given away and there's not adequate, you know, from a consumer perspective, disclosure of that. I think when you're providing legal services, people come to us with their most vulnerable moments in life. Whether in employment, they're sharing with me their psych records, they're sharing with me their medical records, they're sharing with me. I ask for lots of background information to ensure that I have a viable plaintiff. You know, prior legal history, there's a lot of things that I personally collect about my clients. And I have deep concerns that that would be shared and that there would not be proper prohibitions about that. I mean, it's the first thing we learn in law school. It's one of the things that we think about every day in our practices. So that has deep concern about commodification and the distribution of this information for particularly for vulnerable populations, which I think is where we're supposed to be focusing our energies. I also have concerns about breaches for in violation of the rules. We all as attorneys, there's rules about malpractice insurance, and we have to disclose that in our agreements for legal services, whether we have malpractice insurance or not. I would be interested if we're relaxing these regulatory rules, or just in general, how the insurance marketplace is going to interact with these entities in the Sandbox marketplace. And so while I think there is concerns about making sure that there's data for the regulatory agency to see if this is working and how it's working and where it's not, in order to tinker with this and create a viable way to proceed. I think it's a vastly different issue of utilizing consumers' information that they provide in a very vulnerable position of obtaining legal services.
Thank you, Wendy. That is also well said. I think we've seen that there are some issues in what we are doing that are deeply controversial and strongly held views that are quite opposing, and some that are not that hard for us to agree on because they're sort of issues of common approach. Thank you for everybody who participated in today's discussions. I am going to wind them down with a quick focus on what are the next steps. There is a subcommittee meeting for SAGE coming up on the 25th of August, and for SCOPE coming up on the 3rd of September. And then we all convene here collectively on the 17th of September. So the next few weeks are pretty darn busy. When we come back on the 17th, we'll hear from our 2-person teams on each of the 4 rules proposals, and we will continue our discussions led and prompted by the agendas of the SCOPE and SAGE subcommittees. For our 3 new members, look for an email from me sometime in the next 24 hours. I'll talk to you about, among other things, joining one of these 2 subcommittees. And also feel free to reach out to Randy to discuss anything that would be helpful in terms of background information or your desires going forward to participate fully in the organization of our wonderful committee and working on this great task. Thanks, everybody. Have a great Wednesday evening. And with that, we are adjourned.
Thank you.